Good morning, ladies and gentlemen. Good afternoon, good evening, depending on where you're joining us from. It is my pleasure to welcome you to this edition of the Scale webinar series organized by ACIOE Associates. My name is Emmanuel Effiong. I'm the project manager on the Nigerian Scale project here with ACIOE. And it's my pleasure, like I said, to welcome you to today's webinar, where we'll be discussing navigating the legal framework for effective policy advocacy. And I'm going to be welcoming the Advocacy and Engagement Advisor of the Nigerian Scale Project, Mr. Ilya Yohana, at this time to set the tone for this conversation via his opening remarks. Please do take a listen as Mr. Ilya comes on board to share with us his thoughts as opening remarks.
Thank you, Emmanuel, and good morning, everyone. With great delight, I welcome everyone to this Scale webinar series. I bring greetings on behalf of the leadership of Scale. I know that it is going to be a good learning, and within these few minutes of ours, let's please take advantage of the chat box, ask questions, and say and make contributions that can also help us move further this struggle. Thank you, and over, Emmanuel.
Thank you so much, Mr. Ilya. You're setting the tone expertly on the conversation today. There's a lot of legal hurdles and legal bottlenecks that needs to be navigated in the course of effective and efficient policy advocacy. And so this conversation is timely, especially considering the political landscape, which is still transitional in Nigeria as we speak, with a lot of stakeholders coming in and our CSOs and BMOs having to begin to navigate the various hurdles of approaching them, engaging them, and consolidating and maintaining the force in the struggle for effective policy advocacy. His Excellency Judge Professor Epiphany Azinge, OON, SAN, it is my immense honor to welcome Professor to facilitate the session this afternoon. We are so honored to have you, and I'll leave the baton and hand over the mic at this point to you, sir. Over to you.
Thank you very much, Emmanuel, for such a warm introduction. I want to thank you profusely for the invitation to facilitate this topic for the webinar. And I want to say how grateful I am that I will be helping to interrogate the conversation before us. My slide is before us, and I want to go straight into the main introduction. Emmanuel, yes. Well, I will be glossing through some of the topics or the themes, and then there are likely to be overlaps here and there. But let me hope that at the end of the day, we will all converge and distillate as possible all the issues that are very germane and relevant for our conversation. Firstly, I try to introduce the topic, and then, of course, try to highlight the role of CSOs, BMOs, and NGOs in policy advocacy. For me, it is quite introductory and nothing that you may not have heard of before. Firstly, for me, is the idea of a holistic appreciation of the legal framework of a nation. Anybody who is embarking on policy advocacy must of necessity have a clear idea and appreciation of the legal framework of a nation. I will go into details as we progress. Also is the importance of the trust of policy advocacy in a country. Well, I agree that no country can make meaningful progress if there are not organizations and individuals committed to policy advocacy in that country. It is totally impossible for a country to progress accordingly and effectively without people committed to policy advocacy. So we commend and congratulate and applaud those who in the course of their lifetime are committed to policy advocacy in any country. It helps to grow the nation. It helps in governance structure. It helps in maintaining the status quo as far as enthronement of rule of law is concerned, amongst others. So in all, we cannot but commend the CSOs, the BMOs, the NGOs in the role they continue to play in promotion of policy advocacy. So that is quite important and significant in that. Well, again, we try to highlight the intertwine in the role of policymakers, lawmakers, and policy advocacy. One comes before the other, and all obviously converge in what comes out from lawmakers. But the role of policy advocates does not end with even a law being enthroned in terms of enactment. It also continues thereafter. In other words, policy advocates can also help in criticizing, pushing for amendments, calling for review, as the case may be. So it does not stop with lawmaking. It proceeds beyond that, so that if we think that there are some deficiencies that needs to be amended or reviewed in a law that is already in existence, it is for policy advocates to push towards that. So in the frontiers of policy advocacy, a lot revolves around policymakers, lawmakers, and the policy advocates. The intertwine is not something that we can easily gloss over. Then next is the significance of policy advocacy in good governance. I've touched on that already. We cannot but continue to applaud those who, in the course of service, engage in policy advocacy in any form whatsoever. Like Mr. Ilya rightly pointed out, there are variables as far as policy advocacy is concerned, whether at community level, whether at international level, whether at continental level, whether at state level. We have people who are engaged in various forms of policy advocacy, and then we cannot but commend them. But when it concerns the framework, legal framework, especially from a national perspective, certainly, we cannot but keep abreast with the developments as far as the laws are concerned. But in the case of Nigeria, eminence is usually given to the Constitution, which happens to be the supreme law of this country. So we move to the next slide, please. Well, I tried also to look at the general significance of policy advocacy and what it does try to achieve, so to speak. First is to draw attention to critical aspects of public interest. Well, what are the critical aspects of public interest at any given time? Is it in the oil and gas sector? Is it as far as health issues are concerned? Is it as far as democratic institutions are concerned, amongst others? It cuts across. So, but whichever way we look at it, we cannot but draw attention to critical aspects of public interest. And those charged with that responsibility, individually and collectively, the mandate is on those who lead in policy advocacy, and they try to draw attention to critical aspects of it. It is not something given to many. It requires a lot of courage. It requires a lot of commitment. It requires a lot of research. It requires a lot of capacity to distill and draw attention of the public as far as issues of moment are concerned. So we cannot overlook that the significance of policy advocacy helps to draw attention to critical aspects of public interest in matters of governance, amongst others. It also helps to pigeonhole government of the day to its manifesto. One thing that we must not lose sight of is the fact that as far as the manifesto of any party is concerned, when they come into office, they are held to account as far as their manifesto is concerned. More often than not, members of the public gloss over this and try to overlook it. But it is the responsibility of those leading in policy advocacy to try to bring them back to their manifesto, hold them accountable, hold them to account, and make sure you pigeonhole them so that they can live up to their manifesto as far as the governance of the day is concerned. So it is the responsibility of public policy advocates to try as much as possible pigeonhole government of the day. Another thing is to highlight focus of the government to the public. What is government of the day thinking about a particular issue? I wouldn't want to go into political controversies, but we cannot but hold to account certain institutions of government when certain things are not going properly, especially as far as protecting the interest of the public is concerned. At this point in time in Nigeria, we're having challenges of removal of fuel subsidy, for instance. It is important that those who are in that sphere of influence, as far as policy advocacy is concerned, bring to the fore the issues concerning the public in that regard, and what must have informed the action of the government, how to justify the action of the government, how to challenge the action of government. It is the responsibility of policy advocates to do that. And in that regard, it is also the part of the significance of policy advocacy to highlight to the public the actions of government, the reasons behind it, how to justify it, how to obviously call for issues to amend what is right and what is wrong. These are issues for policy advocates to address. Then the next issue that I've listed is how to forge linkage between policy trust and Chapter 2 of the Constitution. For students of constitutional law, one thing that is manifestly clear is that Chapter 2 of our Constitution's fundamental objectives and directive principles of state policy, if clearly examined, is more than the manifesto of any nation, more than the manifesto of any political party, more than the manifesto of any democratic institution. So to what extent have we been able to forge a linkage between policy trust, policy advocacy, and Chapter 2 of the Constitution, economic objectives, social objectives, and so on and so forth? These on their own are policy issues that anybody who wants to lead advocacy in this country must not lose sight of Chapter 2 of the Constitution, because in that is encapsulated anything that anybody will want to think about as far as policy advocacy is concerned. How we've been able to adapt, try to achieve, and possibly accomplish what we have in Chapter 2 of the Constitution, though people think that they are not justiciable, in other words, they are not enforceable. But they are directive principles of state policy. That is where you have the gravamen of policy trust in this country. So to what extent have we been able to live up to it, to achieve the intentions of our founding fathers or the framers of the Constitution? It is for policy advocates to lead the government to the implementation and actualization of Chapter 2 of that Constitution. Again, it's for us to ensure that there is no departure from policy trust. In this regard, once a policy is enunciated, again, it is for policy advocates to make sure that that focus remains intact, that government or institutions do not depart from that policy trust going forward. It is very, very imperative that that is obviously ensured through policy advocacy, one way or the other. Again, we have to educate policymakers on best way to achieve policy objectives. Again, this is the role of policy advocates to make sure that that is achieved and educate policymakers. There are policymakers within government, there are policymakers outside government. Whichever way we look at it, it is imperative that people monitor and ensure that there is compliance one way or the other. And like I already articulated, we have to criticize policymakers when they are departing from the main thrust of policy consideration. Again, this is of significance to policy advocates, and they are the ones to lead conversation, to help to interrogate some of these issues and make sure that this significance of policy advocacy is one that we cannot but continue to ensure flourishes as the case may be. Next slide, please. Well, I now come to the main thrust of this conversation, the creation of CSOs, BMOs, NGOs, etc., basic legal framework. One thing that we cannot run out of, one fact we cannot run out of is that these are creations of organizations, if I may have to use that expression, not institutions. First is for the CSOs, BMOs, NGOs to clearly identify special areas and scope for advocacy. Make sure you first identify which area you want to lead advocacy on or from. Which one? Like we said, is it at the community level? Is it at health level? Is it at economic level? Is it at any other level? You must determine clearly your sphere of influence, which area and scope for advocacy that one. Again, is having identified that you have to aggregate persons of expertise and experience in the area. You cannot take somebody from democratic institutions and put the person in another sphere of influence where he has little or no expertise. It is not an all-comers affair. You must demonstrate expertise in an area in order for you to lead advocacy in that area. More often than not, it assumes that persons involved in policy advocacy are supposed to be more knowledgeable or as knowledgeable as policymakers, even more knowledgeable than lawmakers, as the case may be, because you are supposed to be directing these other groups, the lawmakers, and to an extent, the policymakers. You are supposed to know more than they do. You're supposed to have researched more than they do. So you have to aggregate persons of expertise and experience in those areas. Again, is the fact that, yes, CSOs do not operate in a vacuum. More often than not, you find that some are registered with the Corporate Affairs Commission. Some are even registered as companies limited by guarantee. They are not the same as far as our laws are concerned. Whether you are at CAC, whether you are limited by guarantee, amongst others, this must be clearly spelled out and you must make up your mind. But again, in doing so, you are guided by whether your entity is for profit or as a charity, so to speak. Whichever way you find yourself, the law must obviously guide you to a very large extent. And to that extent, if it is for charity, whether it is a foundation or limited by guarantee, that's fine. But if for any reason there is likely to be a profit ingrained in whatever you want to achieve, then automatically you must be thinking of going to register with CAC. And for so many reasons, so that people can also monitor the internal mechanism of your own organization or company, as the case may be, and follow as the case may be. So it is not an all-comers affair. It is not something that somebody can just wake up and say that I am a CSO, I'm a BAO, or I'm an NGO. No, you must be also working under some legal framework, and that you cannot afford to run away from. If not, you will lack legitimacy and you will obviously not have the recognition that you deserve to have in carrying out your policy advocacy. And for me, in doing this, I urge that you should have, if not a full grasp of the Constitution of Nigeria, 1999, you will definitely have a fair knowledge cut across of the provisions of the Constitution, because you cannot lead advocacy if you are not properly informed of the supreme law of the country. So you should do that and make sure you have a full grasp of that. Especially, I said, of Chapter 2 of the Constitution on fundamental objectives and directive principles of state policy. I believe I have articulated on that more. And then you have to master all statutory instruments pertaining to the sphere of influence. So it depends on whether you, like I said, if you are in the area of election, you should have an idea of all the electoral provisions both of the new amendments, both of the main law and their relationship with the Constitution, if that is your area. If your area is in health, you must have an idea of all the instruments dating back to the beginning of our existence from 1960, as the case may be, those that have been amended, those that have been reviewed, those that have been repealed, as the case may be. We must have an idea of that. Then you also have a duty to research existing frameworks from other jurisdictions. In most of policy advocacy issues, they are always referenced to existing frameworks from other jurisdictions. You must have an idea of comparative issues, where to draw from, where not to draw from. It is important that you research into such existing framework from other jurisdictions. You are not bound to incorporate everything hook, line, and sinker. There are areas you may think you have even preeminence more than other jurisdictions, but there are certainly areas you think that you are fairly deficient and must improve, as the case may be. Research helps in achieving that. And then you will talk about confirming judicial pronouncements, especially those relating to the Freedom of Information Act. I believe that is very, very important, as the case may be, and we must not run out of this. Yes, I said that we have to confirm judicial pronouncements relating to the Freedom of Information Act. I've made reference to Freedom of Information Act deliberately because there are instances where information is not usually available. And the Freedom of Information Act has made it possible for CMOs and CSOs and BMOs and NGOs to write officially to government institutions and agencies and ministries to get information. And the whole essence of the Freedom of Information Act is that when you write such, days are given for people to make those information available. It helps for those in the area of anti-corruption crusade, amongst others, for them to utilize effectively the Freedom of Information Act in that regard. And certainly the institutions, the agencies, the ministries, the government parastatal, they are obligated by basis of the Freedom of Information Act to make such law information available. It helps you to confirm whether you are proceeding on the right trajectory or whether you are on the right path, as the case may be. So that is very, very critical. And then I also mentioned network with some CSOs and policymakers. I believe Mr. Elia also highlighted the relevance, or is it a manual that says that this is an opportunity for people to network with one another in answering the pre-seminar webinar question. There's always a lot of significance and importance when you network with other CSOs and policymakers. It could be within the country, it could be across territorial boundaries. Network with others so that you have an idea and benefit from their own insight and perspective, as the case may be. That is very, very important. So the essence of networking in creation is very, very important. Well, again, enhanced competencies for policy advocacy. Well, background knowledge of public policy is very important for those who are aspiring to get into it. Mastery of governance structure is also important because you are dealing with ministries, departments, and agencies at the federal level. At the other level, at the state level, you are dealing with institutions and, of course, the local government. So that is so grasp of lawmaking process. Again, the lawmaking process in Nigeria is quite clear and well articulated in the Constitution of the Federal Republic of Nigeria. And within therein you find that there is a process for lawmaking, and that due process must be accorded its rightful place in the scheme of things. Do you understand the lawmaking process? Are you sure that there is complete compliance in the law being made? Are you part and parcel of the hearing process in the National Assembly? Have you participated in hearing as a public hearing exercise of the National Assembly? These are some of the critical ingredients that we must come to terms with when we are thinking of leading advocacy. Then appreciation of policy formulation. I'm sorry, what is there is formation, but I would rather use formulation. Do you appreciate the policy formulation trust of the government or of a group or institution? Again, I've repeated this total knowledge of Chapter 2 of the Constitution. There is need for in-depth research on critical aspects of the sphere of influence. Then, of course, capacity building in the area of influence. Capacity building is something that you can never run away from. When you are thinking of enhanced competencies, you continue to build capacity both externally and internally. You build capacity externally when you are helping institutions to grow in their own capacity. But in doing so too, you must also build capacity internally, because you must up your game at any point in time in order to be able to engage with those you are trying to lead in policy advocacy. So capacity building is a very, very critical ingredient in achieving this. Underscoring the priorities of the government of the day. You can also help government to determine their priorities when you are leading advocacy one way or the other. But you must first and foremost determine the rightful priorities of the government of the day in that regard. And underscoring that is very, very important. Build a communication channel with the government. You are not leading advocacy if you are not penetrating the government paraphernalia of government that is responsible for channeling such. If you cannot achieve that, then it's like you are speaking to the deaf. So you must build a communication channel wherein you are leading advocacy in one regard, and it is hitting the target and hitting the bullseye, as the case may be. Influence public opinion through visibility by relevance. So again, you can also lead advocacy and nobody is hearing what you're saying. In that regard, you must influence public opinion. You have to be visible. You have to be relevant, as the case may be. If you are not visible, if you are not relevant, then your policy advocacy amounts to nothing. It could be through the print, electronic media, social media, whichever forum you appreciate, and whichever amalgam of fora that you want to use, it is up to you to make sure that you remain visible and relevant, and make sure that your views count at all times. When you have achieved sufficient enhanced competence at any point in time, the relevant agencies of government will want to hear your views on an issue that is germane and totally relevant to your area of sphere of influence. They will not act without hearing from you. They want to know what your body is saying about X, about Y, and so on and so forth. It is very, very important. So you must make your views count at all times. Well, legal strategies and approaches towards effectiveness and policy advocacy. Again, we are back to law. And I said, clear analysis of existing laws. You must be up to date with the law. You must know what the court has decided at any point in time. You must know the pattern of the legal system that you're operating in. It is important that you are abreast with some of those for it. Highlight areas to be improved upon. Yes, in the course of your advocacy, you want to know whether there is something on disability. And the law on disability, did we get it right? Can it compare or compete favorably with laws any other place? What are the imperatives of the disability law, as the case may be? Again, it is for you to highlight those areas to be improved on if we feel that we are slightly deficient in our own area, as the case may be. Underscore administrative efficiency. One thing is to have a law, another thing is to have it administered appropriately. So definitely in some areas we have more than adequate laws, but we have to continue to maintain that some of them suffer from serious administrative deficiency or lapse. Again, it is for those leading policy advocacy in that regard to ensure that we underscore some of these facts. Then I said that we have to forge an alliance with government institutions, whether we are dealing with correctional centers, whether we are dealing with NAPTIC, the Refugee Commission in that area, NDLA, that is for drug law enforcement, INEC, as far as election is concerned, the judiciary as an institution, and the issues of the judicial activism or lack of activism, the issue of judicial integrity and public perception of the judiciary, as the case may be. Well, we have to also try as much as possible to understand that it is important to forge alliance with the National Assembly, the Budget Office, CBN, military, especially with the terrorism and bandits intervention in this country. What can we achieve through leading policy advocacy in some of these segmented areas? It is important that we look into all this critically and try to understand that we have to find out those that we should be talking to. As far as correctional centers are concerned, those are waiting detention. As far as NAPTIC concerned, how well are they funded so that they can also do their work effectively? The Refugee Commission and the internally displaced persons, are they properly funded in that regard? The NDLA that is currently waking up to its responsibilities, how well are they doing? How well are they trained? How can we avoid and avert some of the issues of accidental discharges that will end up killing people? INEC, have we done well so far? These are areas that we must try to forge an alliance so that we know what we are trying to say. In this regard, we must not lose sight of the fact that we have to formulate policies and lead advocacy against the backdrop of some of these enabling laws. We have to help the institutions to build capacity and ensure compliance. I believe I've raised the issue of building capacity and the importance and significance. We have to develop performance evaluation mechanism. For those who are in the area of judicial performance and judicial integrity, certainly they have enthroned already policy evaluation mechanism to assess the performance of judges, to know how well they are doing, and to make sure that cases do not last as long as eternity, and to determine the efficiency and effectiveness of personal judges in their responsibility. That is also very, very critical. Again, insist on international best practices. Again, this is as a result of comparative studies and comparative understanding. And of course, understanding also and appreciating what we can consider to be international best practices in the scheme of things. And then hereafter, I say that policy advocacy must not overlook the financial strength of a nation. This is very critical because you cannot cut your coat more than your cloth. And we can wish all that we must want to wish to achieve international best practices. But we must be conversant and take cognizance of the fact that our financial limitations must always come to play. There are legal alternates in special areas of policy advocacy. Well, I talked about conceptual issues in special areas, depending on your areas of interest. What are the conceptual issues to be taken into consideration? Well, for me, basic constitutional tenets that we must not lose sight of: the rule of law, and of course, we must take into cognizance that whether the rule of law flourishes in a given environment or not. Separation of powers, whether there is a clear separation of powers, there might not be a watertight separation, but does it operate? Do we have separation of powers in place? Are you leading advocacy in that regard? Are you leading advocacy as far as federalism, the proper federalism as well enunciated by all the authorities in the subject? Are we sure that we are on that right trajectory so far? Even the presidentialism that we are practicing at this point in time, I know that we have variants of federalism, whether American federalism and so on, presidentialism, but which are we practicing? And to that extent, have we been able to pigeonhole the powers of the president, the powers of the legislature, amongst others? Then I come over to fundamental human rights on chapter 4, the rights that we have. Because it is not an absolute right, because there are derogations, as we know. But how well have we been able to implement that? Have we been able to lead advocacy appropriately in that regard, especially areas like right to fair hearing, as the case may be? That is very, very important. And we know that the limitations, if the position of somebody that is incarcerated, waiting for trial for almost 2-3 years, when the punishment for such imprisonment will be about 2 years, we have not achieved anything. Does that not violate the right to fair hearing of an individual? Those who are leading advocacy in that regard should know that there must be something to give, and there must be something to be underscored in that regard. I talked about access to justice. Do we have that? Well, how cases last up to 12 years, moving from the Court of Appeal to the Supreme Court, waiting for trial, that does not amount to access to justice. So we have to also interrogate that area for people who are leading advocacy in that regard, to make sure that we underscore and determine what are the challenges in that regard and what can be done to make sure that we fast track cases, whether through alternative dispute resolution, whether through appointment of more judges and justices, whether we have to remove the judges that are in the mainstream of advocacy and judicial litigation in this country, take them away from election tribunal so that they will continue to do justice, as the case may be, because justice delayed is justice denied, as we often say. Then the Freedom of Information Act, I've already addressed that. And obedience to court order. We have seen people not obeying court order, especially the agencies of government, whether they are DSS, police, EFCC, they are not open to obeying court order. What are the policy advocates doing in that regard? How have they been able to pigeonhole these agencies of government, no matter how powerful they think they are, from playing to the gallery, from the impunity that has characterized the order of the day, and how to get them to obey court orders? And then, of course, ordinarily, the enforcement of rights of people. How well have we been able to lead advocacy in that regard? Then I talked about legislative powers, including investigative powers. Yes, the legislature have the powers to investigate, and they have powers to summon. They have powers to do anything, including subpoena. And then they can also question, interrogate, as the case may be. How well have we been able to achieve this? And who are those leading advocates in that regard? Have we been able to hold them to account, amongst others? Then I made reference to judicial integrity. That I know that some people are speaking so loudly and leading advocacy. Above all is the idea of due process and procedural compliance. Are we sure that the processes are complied with? Are we sure that we follow due process in what we are doing, whether in course of financing, the banking and finance? Are we sure that even in the National Assembly, for purposes of appropriation, bill and acts, are we sure that the due process is usually followed? There are also people who are leading advocacy in that regard. There must bring the proper organs of government to account, make them accountable in that regard, and ensure that due process and procedural compliance is honored. Well, skill set relevant for policy changes and programs. This is my own thinking. It may not necessarily be in tandem with that of those who are steep in policy advocacy, as the case may be. But I'm saying that there is need for critical thinking. You have to reason on your feet. You don't have to be pigeonholed by textbook reading and research work. And I just say critical thinking is very important. I also said research propensity is very, very important in that regard. Do you have that capacity to research? Have you been able to update your research propensity? And writing capacity and articulation. You cannot lead advocacy just by articulating. You must have that capacity to write and articulate, as the case may be. Distillation and analytical deduction. You distill from either what is on ground or what you are able to pull from other places, and you analyze, as the case may be. So distillation and analytical deduction for me is a relevant skill set for policy advocacy. And then legislative interpretation of legislation. Can you barely interpret and interpret accurately either the Constitution or the statutory instruments that exist? Are you in a position? Do you know the techniques for interpretation? As the case may be, that is very, very important for your skills as far as navigating the legal framework is concerned. Policy formulation capacity. Do you know what it takes to formulate policy in the first instance before you can lead advocacy? Can you determine new policy thrusts? In other words, can you break away from what is on ground in order to project to a new dimension? Amalgam of interpersonal skills. We said that repeatedly. You must have the interpersonal skill, the capacity to network, and of course, your approach to advocacy must be very compelling and persuasive, as the case may be. And then generally, I talked about good governance process. Good governance process. Do we understand what we mean by good governance? The basics, the parameters for achieving good governance. Do you have a clear understanding? These are part of the skill set that you need to develop. And then, of course, I will urge that for those who are in the legal framework area, you must have a best idea of the drafting parameters, the drafting skills, drafting of bills, legislative process, as the case may be, because it amounts to nothing in the area of the legal framework for you to lead advocacy if you cannot replicate a bill for another bill, as the case may be. So you must build capacity along the line of learning how to draft a bill in order to push advocacy towards a legislation, a bill that can now translate to an enactment or a legislation, as the case may be. Now, I haven't gone through that route. I concluded by saying that, well, we must have well-established organizational structure that is rooted in the proper legal framework for setting up CMOs, NGOs, BMOs, as the case may be. We must try to have a proper grasp of the trust of policy advocacy and a sound knowledge of the significance of policy advocacy. The enhanced competencies for policy advocacy are thoroughly interrogated. And then, of course, there is need for appreciation of legal tenets for effective policy advocacy. The issue of developing a skill set relevant to policy change I've already identified, and all geared towards promoting good governance procedure. We have to foster policy formulation capacity. And then, of course, for the CMOs on their own, the CSO, the BMOs, and the NGOs, you must have internal management mechanism. More often than not, CSOs and BMOs and NGOs have been criticized for lacking an internal management mechanism. You cannot lead advocacy geared towards control and monitoring of ministries, NGOs, and departments and agencies when on your own internal management mechanism is deficient and you are operating at a deficit. I believe that that is an area that we have to invite CSOs, BMOs to also look at critically in order, because if you are not keeping your house in order, you lack the authority to ask somebody else to do better. I believe that is very, very imperative. Now, lastly, I just said the NGO bill. We know that there is an NGO bill that is drawing a lot of criticism presently in the House, in the National Assembly, almost trying to take away everything that we know about and is going to totally dislocate and dislodge the law on ground. I would want to urge you to take a look at the NGO bill in the National Assembly and then see whether it is something that we think can pass through the lawmaking process and receive presidential assent, whether it would be the best thing for this country going forward or not. That bill is not in the public space. It is not in the public domain. I believe it is part of leading our policy advocacy for you to bring this to the front burner of national discourse and bring it to the public space so that people can also look at it and then try to react accordingly. At the day there will be public hearing on it, people would have been well equipped to articulate and address the issue properly. You must look into it. and there should be people, like I said. So when we consider all these variables, we can now say that, yes, we have an idea and a proper grasp of navigating the framework for effective policy advocacy. I want to thank you for this opportunity, and I wait for questions and answers. Thank you very much.
Thank you. Thank you so much, Professor. That was rich, that was detailed, and it is really, really pleasing to know that it ended with a call to action, the need for all CSOs to begin to create more awareness around the NGO and bring it towards public consciousness before it gets further developed. This has been so rich, so engaging, so informative, and we have a number of questions, and I'd just like us to go right into them. I'll just take them one after the other, and you will do justice to it as we go. Balkisa Bashir, apologies if I didn't do justice to your first name. He's asking, in Africa, we have a lot of corruption around the policymakers. How can we implement effective policy advocacy with this overlying situation of corruption in Nigeria, in Africa?
Yes, we acknowledge that a lot of corruption in our continent. There is no denying the fact. And whether we lead advocacy from today till doomsday, I don't think we can get out of this quagmire unless and until we're able to get the democratic system right. Who are the people we vote into office? How do we hold them accountable, amongst others? I believe that we are partially to blame in that regard, because it is not enough to put a thief in a place and say, don't steal. We must question mark the quality, the capacity, the capability of people that we put in office in Africa. And who are they? How do we hold them accountable? They are not in Botswana, which means it's achievable in Africa, because there are some areas in Africa where we don't have issues of corruption, where things work and flourish effectively. How come that it can work in part of Africa and it cannot work in some other part of Africa where we claim to have democratic system and democracy in existence? So I believe that two things. One, the democratic norms at work, and secondly, and more importantly, the capacity to hold people to account. If we're able to achieve this, I believe that we'll be home and dry as far as corruption is concerned. And then don't make government a lucrative enterprise. No, it shouldn't be. Government should not be a lucrative enterprise. Once we're able to achieve all this, in Africa, we'll banish corruption. So how do we achieve that? And that's what I've stated. Who do you vote into office? I haven't voted the president. How do you hold him to account? So that is my own innocent reaction to the question. But it is important that these people should hold those that they vote into office to account. If we cannot achieve that, then we are living in a doomsday.
Very salient. We try to, if we can achieve making government not the most lucrative endeavor, then we can begin to reduce corruption. Thank you for that answer, sir. Messi Anthony says, is it compulsory to have a lawyer as part of the advocacy team of the CSO? I believe this question is based on the various need that you highlighted of having legal understanding of the Constitution and the likes.
I'm afraid the answer is yes. You cannot navigate the legal framework when you are not a lawyer. You may not. You can read and understand the phraseology or the prose of a draft, whether a constitution or an enactment or a bill, but proper interpretation can only be given by a lawyer. So I believe that there is need. But, you know, people multitask now, so you can have a lawyer who is also as an expert in another area that is non-legal. So to that extent, it doubles as a master in this and also an expert in this. So you can kill two birds with one stone, as the case may be. But it is important that you have a lawyer as far as the legal issues are concerned. There might be need for judgments. There might be need to understand whether there's need to network. We talk about public interest litigation. How do you achieve that? You talk about class action litigation. How do you achieve that? How do you know how to initiate such an action? It is only a lawyer that can advise that in this regard, you need this. In that regard, you need that. I'm not saying that lawyers are the best, no. But as far as legal issues are concerned, I'm afraid they are very relevant, as the case may be.
Obviously, the expertise would best be leveraged by someone who has gone through training in that regard. Moving on quickly, the next attendee is asking anonymously, in researching frameworks from other jurisdictions, which you alluded to, sir, in your presentation, how do we accommodate Nigeria's unique peculiarities and realities?
Yes, I made that point clear that we must not lose sight of the peculiarities of our country. That's why I talked about you must not overlook the financial capacity of a country, of a people, of a nation. No, you cannot. So those peculiarities you must have them at the back of your mind. But the truth of the matter is that you may not be able to enrich what you have before you unless you know how other people have navigated that. It's only when you have been able to understand how other people fared that you can now think of, can we go this route? What are our limitations? We factor in the limitations with what we know is a normative factor from other places. When you're able to harness both, you can now enhance, as the case may be. So it is not a carbon copying, as the case may be, copying uncritically what other people have done. You have to copy critically by fashioning or putting into consideration your own peculiarities, as the case may be. So it's not going to be a wholesome adaptation. You must, with critical modification, adapt what you think is suitable or what you think is not present from what is in your own territory. What can you bring in, but subject to modifications to suit your own local peculiarities, as the case may be.
That's nice, sir. So it's not garbage in, garbage out. You have to see whatever you learn through a Nigerian lens, if you will, exactly, to understand what works when you are learning and engaging from other jurisdictions.
Yes, exactly.
Another participant is asking, what are some of the practical steps to forge alliances with MDAs? I know you spoke about forging alliances as an entry point with policymakers. So what are some practical steps that civil society can deploy to forge these alliances with ministries, departments, and agencies of government?
Well, I believe that is part of the networking skill of a CSO, a DMO, or NGO, as the case may be. You can apply to visit the management, right? That you want to pay a courtesy call on the management for interfacing or for engagement. By the time you are granted that application, the application is granted, you go to the management and introduce yourself, introduce what you are doing. Often than not, you find that people, there is a carrot and stick approach. People will always tell them that we can always help you to build capacity in this area or in that area, as the case may be. Even the background of that MDA, as the case may be, any of the ministry, department, and agency, tempt them with something. Tell them that you are capable of bringing something to the table. Tell them that you can help them build capacity one way or the other. By the time you do that, you may not in any way hold them to finance that. You can tell them you can do that on your own. By the time you start along that framework, you find that you have been able to forge an alliance. Once you have done it once, you can always do it again. You are already on their list and you can always engage with them. You've achieved that, and so on and so forth. If you do that, I believe that you will be able to forge that linkage and alliance easily, and then it will continue to grow from there. So they will recognize you, you will help them to build capacity. They will also take you as a partner, and in future occurrences, they will always want to invite you and ask you, can you help us with this? What do you think about this? And can you help us develop, and so on and so on. So there's a lot you can do but you must reach out. You must make yourself visible. You must make yourself relevant, as I said.
So don't just go hat in hand, show them value. Once they respond to your value, they can realize what you're bringing to the table that is mutually beneficial. You can begin to forge those alliances. Thank you so much, sir.
Thank you.
All right. Oluwakemi Eluma is saying, thank you, Prof, for the insightful session. Please, is Chapter 2 of the Constitution the most important part as regards civil work? If so, why is there more orientation? Why is more orientation not done around it? So basically, why has there not been more orientation, more interest pulled towards the Chapter 2 of the Constitution if it is indeed the most important for civil work?
Well, it depends on the background, because a lot of work has been done in that area. A lot of work. I believe that at the Nigerian Institute of Advanced Legal Studies, under my watch, we did so much in that regard. Generally, people say, or people used to say, that Chapter 2 of the Constitution is not justiciable, it's not enforceable in that regard, but we have tried as much as possible. We even went as far as bringing in the former Chief Justice of India. And India was the place that we first adopted the Chapter 2 of the Constitution from. We were able to bring the former Chief Justice of India to come to Bhagwati, to come to Nigeria, and even discuss with the justices of the Supreme Court, as the case may be, in order to show them how India has been able to make Chapter 2 of the Constitution very, very enforceable. But that is as far as the issue of justiciability and enforceability is concerned. That is the harmonious construction of using Chapter 2 of the Constitution in Nigeria to also interpret Chapter 4 and vice versa of the Constitution on fundamental human rights. So there's a lot of conversation in that area, so much. But what people cannot gloss over, whether we talk about justiciability or not, is the fact that if you look at it, you see that are we courageous enough to tell political parties in this country that we don't need your manifestos, that we have a manifesto of a country on its own ingrained in the Constitution, Chapter 2, whether it is social, political, economic, and so on. All the objectives are encapsulated. So what are you looking for? Make sure you follow that directive principles of state policy. Maybe people have not pursued that line as vigorously and robustly as we ought to. But all that people keep saying is that Chapter 2 is not justiciable. It is much more than that. It is much more than that. We must look at that fundamental objectives and directive principles of state policy as a means of an instrument of governance on its own, more than whether it is enforceable or not. If it is enforceable or justiciable, that is an extra. But can we use it as an instrument for determining our movement as a people towards the right directive, as the case may be? So for me, yes, maybe we've not done that sufficiently. Maybe we don't have people leading advocacy in that regard. If that is what can be taken away today, that's a big, huge one. But let people not be diverted from this objective to always saying that Chapter 2 of the Constitution is not justiciable, it's not enforceable. But it is there. And we must lead advocacy in that regard. So let it be a challenge to some TSOs so that they concentrate on that and lead advocacy in that regard.
Yeah, very, 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 very insightful. And it will be helpful if members of CSOs and NGOs here present working in governance can pick that as an advocacy ask, maybe aligning and putting more spotlight on the Chapter 2 of the Constitution and making presidential campaign councils and other campaign councils to reflect that in putting together their manifesto for elections. Very insightful, sir. Daniel Akpan is saying, most CSOs in Nigeria are funded by foreign agencies such as USAID, UKAID, then BMGF, Ford Foundation, Makoto, and the likes. And this at times creates some acrimony with policymakers who don't trust the overall objectives of these foreign entities. How can we navigate these as we move to forge alliances and consolidate on policy advocacy trust?
Well, the issue of funding by foreign organizations is one that I have never been comfortable with. I have never been comfortable with that. To a very large extent, without sounding escapist, is the fact that there's no way that he that plays the piper does not dictate the tune, to a very large extent. And that's one. Two, for me, is the fact that what is it that they fund that Nigerians cannot fund? What is it that they fund? How much is it that they bring it to the table that Nigerians can? Because we have not been able to look in that regard, in that direction. What is it? How much do they bring to the table? How much do they bring to the table that some of the billionaires scattered all over Nigeria cannot? It is not through burial ceremonies. It is not through multi-marriages. It is not by buying private jets. That is not how a country can develop. Let us channel the thinking of some of the wealthy Nigerians towards understanding. We cannot but continue to applaud what the Melu Foundation is doing. We must applaud it. If they can do that for the whole of Africa, we have to ask questions. How many have we done in Nigeria? What is it that he cannot fund or that foundation cannot fund? Why do we run away to all these people? I don't know, but that is my thinking. And I know it is doable. So it would appear that running to any of these international bodies is a refuge for ourselves. And that's why people continue to ask, how sincere are the CSOs and the NGOs? Is it an avenue for money making on its own? So why do we like going west when we have not explored internally? Then lead advocacy so that Nigerians will also be funding policy advocacy in that regard. Lead advocacy to that. Let Nigerians fund it. So I may be on the wrong side, but it has always been my thought process that let us explore options locally instead of, we can still forge the same alliance. Indeed, let it be a partnership. At worst case scenario, let it be a partnership on equal basis. Let it be a partnership. And I say this authoritatively because way before I took over as Director General of NIALS, we engaged in performance evaluation, judicial integrity performance evaluation. But we insisted that it must be on equal footing. We insisted it must be on equal footing. It was not fully funded by anybody. It was on equal footing. And when at the end of the day, they were trying to tailor the report of our research to suit an interest that was diametrically opposed to what we believe and what we consider to be the right thing, haven't conducted the field research ourselves, we said no. And that brought it to an end. They were trying to tailor our report to suit a particular objective. We refused. How do we achieve that control in some of the things we're doing if we only continue to receive funding from foreign institutions? I don't think it has helped us. I don't think it's capable of helping. And I believe that it can be done locally, and we can continue with our research locally and still achieve what we want to achieve. Any other person that wants to support you in any form will come in as a partner so that you have equal say, and nobody can tailor your thinking to suit a set objective. I don't think that will help us.
Thank you so much, sir. And that is, I believe, why one of the important focus of the SCALE project is encouraging and enhancing the capacity to engage in local engagement, aligning with the various entities, both in the private and public sectors that we have within our locality here in Nigeria. Very insightful. Moving on to the next question, Ahmad Usman Dada says, what steps does an NGO take if after paying a policy advocacy visit to an institution, but nothing changes, even after receiving a promise by the institution, the change will be effected for good? So you go for an advocacy visit, you get a commitment, but nothing changes. What do you do next?
Well, like I said, the advocacy visit is for you to forge an alliance, like I said, promise to help them build capacity. And if after that, you have, the first thing you have established is you have forged an alliance. The second thing is to assess the impact of the capacity building and the alliance you have forged. It has opened the doors. If nothing changed after this, you have to revisit. You have to now lead advocacy. It is now an opportunity for you now to weigh in. It's not going to be all friendship. I believe that you don't forge alliance for a particular purpose. You don't forge alliance for the sake of, okay, I am now a partner or a friend to this ministry or to this department or to this agency. So if they've done anything wrong, you cannot weigh in either aggressively or robustly, as the case may be. No, nobody should be spared the rod in that regard. When you have reached out to them, you've been able to forge an alliance, you've been able to build capacity with them, and they still fall out of line. Go after them. Use the Freedom of Information Act, expose them, ask questions, tell them, command them, using the Freedom of Information Act. We need your report on this. In the last 2-3 years, we need this report from you. They are compelled by law to offer and produce it. They must produce it. Even if they lie, let them try to see if they can get an injunction. The law does not guarantee that. They must offer that information. And when they have offered information, you make a critique of it, critically examine it, and produce a report from it. Put it in the public domain. You think things will change. It's just that some of these NGOs, either they don't want to rock the boat for obvious reasons, pecuniary measures, or they don't know that they have an option in order to get the information they want. Amagu, if you have an interest and you notice that a particular MDA is not doing the right thing, do the Freedom of Information Act, invoke it on them, write to them, give them 7 days that you want this information. And if they produce the information, go after them. Go after them. Go by publicizing this, criticizing it, you will see everybody will sit up. It has courage of conviction. The courage of conviction, people must speak up when the need arises. They must have that courage of conviction to speak up. That is it. But you must make sure that your hands are also clean, because you cannot, when your hands are soiled, go after somebody, aiming the person has soiled his hand. Your own hands must be clean. So if you build capacity, make sure that you do it within the framework of the law. If you are forging alliance, do it within the framework of the law. Do not compromise at any stage. If not, you've lost the right to inquire or to critique, as the case may be.
Very insightful. I picked out 3 very vital C's from your response. Don't compromise and have the courage of conviction. Thank you so much, sir. We'll just take the last 2 questions. I see a participant's hand is up. Please, Amos, kindly drop your question if you have one in the Q&A tab, and we'll bring it to Prof's attention. Thank you. Ibukun Aijebe says, how can policy advocacy efforts be sustained over the long term for lasting impact in Nigeria?
Well, for me, it is a matter of commitment. It is a matter of dedication. It is a matter of trying to add value, sincerely, honestly, without any intention to make money out of a process. That's the only way. Because certainly something that is not obviously lucrative, but can always be seen as service to the society, may not be tempting to many people, may not be tempting, may not be sufficiently inviting to many. So to that extent, you find that those who show commitment today may lose interest tomorrow, just because it does not bring food to the table. But we don't lose sight of the fact that there are so many things that is done in the West that we cannot replicate here. I don't know whether in some of the things we do, whether we have escalated the whole essence and significance of volunteerism, people volunteering. And you notice that in the West, people volunteer for many things. If we see NGOs in Nigeria as a form of volunteering organization, then we will definitely not lose commitment, we will not lose focus, because we, ab initio, we are not expecting to make financial or pecuniary rewards from it. But have we been able to cultivate a spirit of volunteering, just as they have done in the West? So here, peculiarity of a people comes to play. Well, how come that we cannot escalate volunteerism as a way of life for our own people? So all I'm trying to say, in effect, is that if we learn to volunteer, we can learn to sustain NGOs for as long as possible without losing interest. We know that it is not a sprint, it's a marathon. Certainly not a sprint, it's a marathon. So it will take a long while to change the mindset of a people and get them to do the right thing. But we must be relentless in pursuing that objective so that we don't lose focus somewhere along the line, and then the interest will wane. So my position is that we'll see it more from the perspective of volunteering to serve your people and pursuing it with dedication, devotion, as the case may be. So if we're able to do it as a form of volunteerism, I think we can sustain our momentum until we're able to achieve our set objective. That for me is the way we can navigate through it. If not, once we feel that it's not putting food on the table, we're gone. That is not what obtains in the West. Even if it is not bringing food to the table, the satisfaction is that we are serving our people and money can now come from other places.
Thank you, sir. So as NGOs, as CSOs, identify your why and remember that why and let that drive you, and not necessarily material gains, so that you can sustain the efforts you're making in pursuing for lasting impact and development. We'll take the last question, sir, from Kemi Eluma again. And it goes, for an effective policy advocacy, data protection and privacy legislations are critical. What, in your opinion, should public advocates, policy advocates, I beg your pardon, pay attention to while handling critical data in their line of duty? So a question around the handling of data and then privacy legislation for advocates.
Well, certainly we cannot lose sight of the fact, indeed it's given, that people leading advocacy should have a good knowledge or good grasp of data protection matters and matters of privacy and confidentiality, as the case may be. But again, is to have a great grasp of these two issues so that you know the limitations. The ironically is the fact that data in Nigeria is something that is hard to come by. It is hard to come by. Therefore, it is even harder to analyze. Again, it depends on what type of data are we looking at. Are they data that we can easily get on the net, or certainly not? With greatest respect, again, when I was at NIALS, we were trying to see how well we can help to develop data from the Office of the Statistician General of Nigeria. How do we? You find that we are deficient. With the greatest respect to everybody, we've been deficient for ages. Which data can you get from the available statistics in Nigeria? Maybe 15 years back, 12 years back. You can't even get 5 years anywhere, because we're not given to that. So I asked, which data are we talking about, to be protected or not? Yes, but in the realm of privacy and confidentiality, fine. It depends again. We have to argue it. Which area of privacy, confidentiality? Is it government confidentiality? Is it private confidentiality as regards the health of an individual, medical law, and the rest of fine? We can understand that. Medical confidentiality amongst others. Or is it public confidentiality? In other words, certain issues of government are not likely to be disclosed until a period of about 10 years or 15 years, as the case may be. So in America, they say a particular document has been declassified, so it can now come into the public realm. But it must be declassified because it is time for it to be declassified. But classified documents are not supposed to be in the public domain. Even if the president is writing his memoir and it is not time to declassify a document, it does not have the right to declassify and breach confidentiality. All I'm trying to say is we understand this gamut of the law, but all we're saying, to what extent the documents may not be available, this data may not be available. So let us even think of how do we sustain data collection and protection before we can now start thinking of how to manage the data, because the data is not available. And again, a data that is already in the public space need nobody to protect it anymore because it's in the public space. You don't need to protect a data that is in the public space. So these are variables, but whether the question is relevant, very germane. But I am now trying to color the question by telling us the challenges we have in the first instance before we start thinking of what to protect and what not to protect. But the law certainly is in place.
Very important. And maybe another advocacy act there for our practitioners in the House on pushing for data protection, data gathering, and data sieving mechanisms in Nigeria, up-to-date data. Rosanna Empowerment Foundation is asking a question that has the connotations of funding by foreign agencies, which you've already attempted. But the angle they're coming from is, what role does evidence-based advocacy play in strengthening the credibility of NGOs? So if an NGO is funded by a foreign person and they use those funds to gather evidence, and how does it strengthen their credibility, or how does this evidence gather strengthen their credibility when putting forward policy recommendations to policymakers in Nigeria, especially considering that they are funded again by foreign agencies?
Well, it brings to fore the issues that I have tried to address by questioning the rationality and the viability of foreign funding. Have we ever stopped to ask ourselves the question, how come that we have more information about Nigeria outside than inside? Have we asked ourselves that question? Rosanna Foundation, it is as a result of this question. People gather evidence, people gather statistics, and in their report to fund donors and founders or funders, forward the report with all the information back to their destination. Could be UK, it could be Canada, it could be anywhere. And they have that. And we don't have it in Nigeria. Because I don't think there's any law that stipulates that NGOs or CSOs, DM, that any reports of their research work forwarded abroad must be domiciled in Nigeria as well. Yes, I don't think there's a law to that effect. Because there is no such law, you find that most of the time, the funder is the one getting all the information, whilst the country of residence or domicile, as the case may be, does not have that information. Is there a law to that effect? And where will that report be lodged, as the case may be? I don't think there's any law to that effect. And so we're deficient in that regard. In that respect, we are deficient. There is deficit of data in that regard because it is evidence-based. So when Europe or UK or Asia or any foreign country tells us that Nigeria is a nation of 180 million people, we are in Nigeria here claiming that we are more than 200 million. And then you ask yourself, where did they get the information from? You ask yourself, where did they get there? But we know that their information is from within. We are on the verge of projections, trying to figure out how many are we. But information flowing from Nigeria through foundations and donors and funders is to the fact that we are this. We have done our research and we have forwarded information to them. And they now utilize that information to give a much more accurate picture of what is going on in Nigeria. So you can understand the challenge we have. So they have more information about us, from us to them, not within us, because it is not domiciled within. That for me is an issue to be looked into critically, because where other people are giving you information about your country, much more accurate than you have, something is fundamentally wrong. And the earlier we revisit that, the better for us.
Thank you so much, Professor. I like that all your answers have been laden with advocacy tags and things that our CSOs can pick with and run with, and various areas that they can begin to think about building advocacy campaigns and initiatives around. It has been a pleasurable time going over this conversation with you, and that brings us to the end of the Q&A for now. I would love for us to continue, but we'll have to begin to wrap up at this juncture. Before we move over to the closing formalities, we've seen from the chat box a lot of you expressing how insightful and educative this session has been, but would like to have a metric to measure the new learnings that you've gained from this session. And so at this point, the post-webinar poll is going to be projected. Please take the time to attempt the poll and let us know the percentage of new knowledge and new learnings that you've gained from this session, how it's going to improve your work as advocates. We understand that it's going to improve it, but let us know the extent at which these improvements will happen and other questions that are there in the poll. Please just take the time to attempt it before we begin to wrap up and bring this very interesting and exciting webinar to a close. Okay, to wrap up the webinar, it's my pleasure to welcome the managing partner of ACIU Associates, Mr. Ekene Misiche, for his closing remarks. You're welcome, sir, and over to you.
Okay, great. Can you hear me? Just want to make sure if my sound is good. Yeah, thumbs up is great. First of all, let me just start by thanking USAID, Palladium for their support in doing this together. I believe that without a collaborative efforts, some of the work that we're trying to do within the advocacy space would not happen. And I want to honestly appreciate their time and their support and their guidance in what we're trying to do. I also want to give thanks to Professor Epifania Zenge, SAN, for his fantastic insights and wealth of knowledge, especially in this space. I believe that with the insights you have drawn today, quite a number of people within our organization and our various organizations will take this and run with it. And I also want to give thanks to the ACIUE staff, my colleagues who were working around the clock trying to put all this together. It wasn't easy, but thankfully this has happened on a Friday. And I also want to thank the audience for also participating in this. So in conclusion, all we're trying to say is that the law is not the end in itself. It's just a means to an end. It is a tool through which we can shape a just and prosperous society. So let us use the tool wisely and bravely, for our nation, Nigeria, deserves nothing less. So on this note, I want to honestly say thank you for being part of this webinar. God bless you all, and indeed, God bless the Federal Republic of Nigeria. Thank you.